Good morning, class.
Good morning, Miss.
Good morning, Miss.
Today, we are going to discuss the judgment made by Lord Bingham of Cornhill in Fairchild and Glenhaven Funeral Services, 2003. In a generality of personal injury action, it is of course true that the claimant is required to discharge the burden of showing that the breach of which he complains caused the damage for which he claims, and to do so by showing that but for the breach he would not have suffered the damage. The elements required for a successful negligence claim are a duty of care, breach of that duty, that the breach caused the loss, and remoteness of damage issues. Only once it has been established that there has been a breach of duty of care does the court consider causation and remoteness of issues. As Lord Nichols set out above, the question of causation is analysed in two stages. The first stage is factual causation. The general test which helps to establish causation is the but-for test, which poses the question of whether the loss would have been sustained but for the relevant act or omission of the defendant. If it would, the defendant is normally, though not always, absolved at this point. If this first stage can be found, then the courts will consider whether there was a legal cause, which requires the courts to make an assessment of whether the link between the conduct and the ensuing loss was sufficiently close. In deciding this, judges will ask whether a particular event broke the chain of causation and use terms such as direct, proximate, foreseeable, or remote to describe the relation between an act or omission and its consequences. Causation in legal terms refers to the relationship of cause and effect between one event or action and the result. It is the act or process that, an effect. In the personal injury case, one must establish causation, meaning that it's not enough to show that the defendant was negligent. The negligence must be what caused the complainant's injuries. An application of the but-for test can be seen in the case of Robinson and the post office. In this case, a doctor administered an anti-tetanus injection on the plaintiff without conducting tests to find out whether the plaintiff was allergic to anti-tetanus injection. Plaintiff later contracted encephalitis as a reaction to such injection. The court held that defendant not liable, as even if a test had been done, the allergy would not have been discovered in time. Today, we have Miss Yvonne and Miss Catherine as our guest lecturers to explain further on this topic.
Good morning, class. My name is Yvonne, and I'm here to talk about the factual causation. Before I start, can someone tell me what you understand about factual causation? This will contribute to your 10% tutorial participation mark.
It is when a claimant needs to show that his or her injuries were the result of the defendant's actions. Without this cause, the accident that resulted in the injury could not have happened.
Anyone have a different explanation for this?
Factual causation is the first rubric for cause, in fact, where the focus is backward-looking and attention is directed to a simple question of what happened, of whether the defendant's conduct caused the injury. It is resolved by the production of evidence and the drawing of inference from what evidence. Whether a particular condition is sufficient to be causally relevant depends on whether it was a necessary condition for the occurrence of the damage.
Well done. The main strength of the test lies in its ability to be simple enough to undergo everyday implementation. This was further explained by Lord Dining in the case of Koch and Kirby, where he said that if the damage would not have happened but for a particular fault, then that fault is the cause of the damage. If it would have happened just the same, fault or no fault, the fault is not the cause of the damage. Before I proceed, anyone wants to volunteer to share with us about the landmark case for the but-for test?
The landmark case is Barnett and Chelsea from 1969, where the court applied the but-for test to examine whether the hospital was liable to the claimant's husband's death. It was found that because injury to the claimant would have occurred regardless of the defendant's conduct, there was no factual causation.
Well done. So we can see that the but-for test enabled the court to clearly establish that although the hospital had breached their duty of care, the breach wasn't the direct result of the deceased dying. Therefore, it was to be eliminated as a cause of death. From this, we know that causation is not always established despite the party breached their duty of care. Well, give a guess on a case where the but-for test is inadequate and explain why.
It can be seen in a case of Lewis, 1952. It involved two hunters who fired their guns in the direction of the claimant, but only one bullet had hit the claimant. Yet the court was unable to distinguish which gun it was that had fired the bullet. Based on its ineffective nature in cases exhibiting the presence of indeterminate causes, in such situations, the application of the inquiry does not yield any answers concerning the main cause responsible for the occurrence of injury or harm on the plaintiff. Because it was unknown which gun had fired the bullet, both hunters were found jointly liable.
So this brings us into multiple tortfeasors, which is a weakness of the but-for test, because it would find neither of the defendants liable, which would lead to the case being unjust. It is not possible for the but-for test to be applied in these circumstances. Okay, now let's move on to the landmark case for the but-for test in Malaysia. Did anyone prepare any Malaysian cases for this topic and would like to share with us?
I don't mind sharing with the class. In Malaysia, the landmark case on the application for but-for test can be seen in the case of Swamy and Matthews and Arner, 1968. The claimant was given an injection which was alleged to have caused his paralysis. The federal court upheld the earlier decision on the grounds that it was not caused by the injection.
Another case that I found was Ang Chai Ha and Sriwijaya Transport Co., 1974. In this case, the defendant's bus collided with the claimant's car, which caught fire. The claimant died due to extensive burns. The defendant admitted negligent driving but contended that the fire was due to the petrol in the claimant's car. Since the petrol was intact and the actual cause was the spark produced in the collision, the defendant was held negligent.
Good job, Melody and Ray. If the defendants provided by the claimant was sufficient to satisfy the cause in fact requirement, the wholly causative injury or damage caused should suffice a fortiori, which means from the stronger argument. Hence, the defendant's breach must be the substantial cause of the damage. Despite that, it does not mean that the question of causation in fact should be restricted to a basic application of but-for test only, as it is unworkable in some circumstances. One major weakness of the but-for test involves situations whereby multiple causes are capable enough of causing harm. In such situations, the problem lies in the ability to single out a single action as the causative factor of injury on the plaintiff. It is divided into two parts: material contribution to harm and material contribution to risk. Class, anyone did their research and would like to share about their two parts?
Where there is material contribution to harm, we need to consider the extent the defendant's act or omission has contributed to the plaintiff's injury. We need to look at the facts and on a case-to-case basis. This is illustrated in Bonington Castings and Law, 1956, where the defendant was at fault for not ensuring that the mechanism was functioning properly. Defendant was held liable, and the court held that it was sufficient for the plaintiff to prove on a balance of probabilities that the defendant's failing had made a material contribution to his decease.
Well, can anyone give a guess on what you need to consider when it comes to material contribution to risk together with examples?
We must consider that there is an increased risk to the plaintiff by the defendant's failure to do something.
In UK law, McGee and National Cobalt 1972 can be used as an example. Defendant was held liable for providing inadequate washing facilities. Where there is more than one possible cause of injury, causation can be proved if the claimant can show that the defendant's negligence materially increased the risk of injury occurring.
In Malaysian law, we can also refer to Dr. K. Sivananthan and the Government of Malaysia from 2000. Here, the plaintiff discharged himself from the hospital due to the dissatisfaction with the care he received and sought treatment in another hospital. 9 months later, the plaintiff's leg had to be amputated. The court held that the lack of blood flow was already at a severe level when he was admitted in the second hospital, hence the attending doctor could not be said to be negligent. Wilshire's case was cited with approval that where the plaintiff's injury was attributable to a number of possible causes, the defendant's breach of duty itself does not give rise to the presumption that the defendant had caused the injury.
Not only in multiple causes, but-for test was also challenged by the loss of chance factor, which was argued that but for the defendant's negligence, it increases the possibility of a poorer outcome. A chance has some value in itself, and that losing a chance through the breach of another is a sufficient loss to give rise to a claim in negligence. Often, these are medical negligence cases, and the general rule would be that the courts are unlikely to compensate the claimant for the loss of chance if it is less than 50%.
Miss, why does this appear to be very similar to situations in which There are multiple causes of harm despite having different relevant case law. How can we distinguish them?
Well, it can be distinguished by asking whether the facts of the case involve multiple, equally likely causes, or whether they involve a loss of chance of avoiding harm. It can be seen as a strength of the but-for test, as it helped to determine whether the hospital was negligent for the claimant's disability, although the hospital had breached their duty of care. However, the law regarding loss of chance is not without criticism. In Hodson's case, it was clearly the mistake of the hospital, and it turned the possible recovery into a lifelong medical condition. Consider the situation where there is 49% chance of recovering, he would still be unable to claim.
So, Miss, can we use Greg and Scott from 2005 in loss of chance? Because in this case, the child developed avascular necrosis after his hip injury was diagnosed and treated. There was a 25% chance that the injury would have healed and 75% chance of him developing the condition.
Yes, you can, and that's another good example for loss of chance cases. You can read the dissenting judgment by Lord Nichols, where he stated that it is anomalous in law that a patient's prospects of recovery are non-existent when they are below 50%. Does this render meaningless duty owed by doctors to patients with less than 50% chance of recovery?
Can I add on? Lord Hope also made a remark that the claimant's best course of action would have been for pain, suffering, and other consequences of the tumor. Loss of chance should be allowed via assessment of damages, not through definition of the damage suffered.
Good job, Rafik. Loss of chance cases can also involve financial losses, where the claimant missed out on the chance of a lucrative deal or well-paid job due to defendant's negligence. Does anyone care to tell us more about this?
Yes, damages for loss of chance have been allowed in cases where the loss is purely financial, which can be seen in the case of Stovall and Ballas, 1996.
To wrap up my talk for today, as with many elements of negligence, matters of causation are decided on the balance of probabilities. Since the burden of proof rests with the claimant, the onus is on him or her to argue that had the defendant not acted negligently, their harm would likely not have occurred. However, this arrangement can be seen as troublesome from a theoretical standpoint. Focusing specifically on the establishment of factual causation, the but-for assessment acts as a common approach for determination. However, the inquiry is ineffective in situations involving multiple causes, indeterminate causes, and consecutive causes. Thank you.
Good morning, everyone. I'm Miss Catherine, and I'll be talking about the topic of factual causation as well. I'll start off by talking about the topic of multiple tortfeasors. Does anyone want to share what multiple tortfeasors are about?
In a case involving multiple tortfeasors, the damage is caused by negligence, but there is more than one party which could have been responsible for the damage.
Well done, Rafik. In the case of Fairchild and Glen Helen Funeral Services from 2002, 3 separate claimants contracted mesothelioma as a result of their exposure to asbestos during their various courses of employment, referring employers. By the point at which symptoms of mesothelioma emerge, the cancer is in too late a stage to be deemed treatable. Only a single incident of exposure to asbestos fibers is necessary for the cancer to be caused, and subsequently repeated or prolonged exposure does not impact the severity of the cancer. Whereas the 3 claimants had all experienced asbestos exposure with each employer, it could not be determined which employer was the most likely source of the causative asbestos fiber. Does anyone remember the outcome of this case?
Me. The House of Lords held that where a claimant could demonstrate that one employer had materially contributed to their asbestos exposure and thus had materially raised the probability of the claimant contracting cancer, the claimant could claim total compensation from them.
Thank you. It is also possible for certain events to break the chain of causation between the defendant's actions and the claimant's injuries, thus relieves the defendant of liability. There are 3 distinct types of intervening acts: those taken by third parties, those taken by the claimant themselves, and those which are acts of nature. Third-party acts take place after the original harm to the claimant or their property. The general rule involves asking whether the third party's acts can be tied to the original harm, as seen in Scott and Shepherd 1773. Can one student share about the facts and outcome of this case?
Me. In this case, the defendant tossed a small lit firework into a crowded marketplace. It landed on a seller's market stall, who tossed the firework away to protect himself. It landed on another seller's stall, who then also tossed the firework away, where it hit the claimant, exploded, and blinded him in one eye. The court held that the defendant was responsible for the claimant's injuries, although there had been intervening third-party acts. They could be considered consequences of the original harmful act.
Thank you, Ray. However, if an unreasonable act is undertaken by a third party in response to a negligent harm, that will break the chain of causation. In the case of Knightley and Jones and others, the defendant negligently caused a car accident. In dealing with the accident, a senior police officer neglected to close the tunnel in which the accident had occurred. Another police officer, who was on a motorcycle, had to ride against traffic up the tunnel to close it. This police officer was involved in another collision and was badly injured. The court ruled that the original defendant was not liable for this injury. The senior police officer had acted unreasonably in failing to close the tunnel, and so it was he who was liable for the motorcyclist's injuries. Now, can someone give me an example of a Malaysian case related to this topic?
For Malaysian law, we can refer to the case of Billion Origin and New Bridge Networks, 2006. In this case, the plaintiff and the first defendant are tenants of a building and have a contractual relationship with the second defendant, the owner and the landlord of the building. The first defendant's premises is right above the plaintiff's premises. The first defendant had left a fan on in his server room for 6 days, which subsequently caught on fire. Water was then discharged from the sprinkler in the server room to put out the fire. The plaintiff's premises were flooded due to water seepage from the first defendant's floor above. The first defendant admitted at fault for leaving a fan switch on, which resulted in a fire damage, and argued that the second defendant's employees to conduct a thorough check and turn off the sprinkler constituted a novus actus interveniens. However, the court rejected the first defendant's argument and held that there is no break in the chain of causation. It is foreseeable that leaving a fan on for 6 days would run the risk of fire. The first defendant is therefore liable for the damage.
Excellent. Thank you, Melody. Class, take note that it is also possible for liability to be apportioned between the original defendant and the third party. In Wright and Lodge and Shepherd, 1993, a driver broke down on a busy road and failed to move her car onto the hard shoulder. This caused a lorry to crash into it. The defendant negligently swerved to avoid the crashed lorry onto the other side of the road, causing another crash to occur. The courts ruled that whilst the defendant had acted unreasonably, the ultimate cause was the first driver's negligence, and so split the cost of damages between the first driver and the defendant. Furthermore, there also arise third-party acts which are unrelated to the original harm. The general rule is that whether an act or occurrence is severe enough to constitute a novus actus interveniens depends largely on the circumstances of the case itself. This can be seen in Baker and Willoughby, 1970. Does anyone want to share their knowledge on this case?
I can. In this case, the claimant was originally knocked down by a negligent driver and was suffering from a permanent stiffness in his leg as a result. Before the case went to trial, the claimant was involved in an armed robbery, during which he was shot in the same injured leg and his leg had to be amputated. The court ruled that, although the original injury was overtaken by the new injury, that this did not constitute an intervening act within tort. It was instead ruled that his compensation for the original injury should remain in place. The robbers were never caught and thus could not be sued. So to end the original compensation claim would leave the claimant without remedy. It was held that the original claim for loss of earnings still stood, and the claimant still could not work properly, even if a new injury was now the prevailing cause of this.
Good job. Thank you, Ray. There also exists the possibility for the claimants themselves to take an intervening act, breaking the chain of causation between the defendant's acts and the eventual injury. This is shown in the case of McHugh and Holland and Hannon and Cubits. Does anyone remember what happened in this case?
I do. In this case, the claimant was injured at work due to the negligence on part of his employer, which left him with a weakened leg that was prone to giving way. A few days later, he attempted to move down a flight of stairs which did not have a handrail. The claimant's leg gave out and the claimant jumped down the remaining 10 steps in order to land on his feet rather than fall. This fractured his ankle and left him with a permanent injury. The claimant then sued his employer again, asserting that the new injury was a consequence of the old injury. Whilst the defendant accepted liability for the original injury, it disputed liability for the second injury. The courts agreed, ruling that the claimant had acted unreasonably in descending the stairs without taking proper precautions. Noting the unforeseeable nature of the claimant's new injuries, the courts therefore ruled that the claimant had taken an intervening act in descending the stairs unsafely, and the second claim failed.
Very good. Thank you, Rafik. There also exists a third category of intervening acts which are due to the nature itself. Such an act can be seen in the case of Causation Steamship and Royal Norwegian Government from 1952. Can two students volunteer to talk about the facts and outcome of this case?
The claimant, which is the Royal Norwegian Government, had one of its ships damaged by the defendant in a collision, and the defendant admitted fault. This meant that the ship had to be repaired temporarily in the UK before it sailed to the US for permanent repairs to be carried out. During the crossing, the claimant's ship sustained further damage when it was caught up in a storm. The claimants asserted that, but for the original collision, the ship would not have had to have made the transatlantic journey and so would not have sustained the additional storm damage.
Later, the courts rejected the claim, and the defendant was only held liable for damages arising from the first collision and not the subsequent storm damage. The storm was held to be a novus actus intervenes, and so the claim was based on a faulty reading of causation. In particular, the courts noted that the storm damage was incidental, it could have happened to any ship on any voyage, and thus could not be held to be a consequence of the original collision.
Impressive. Thank you, Melody and Ray. Now, I'll be talking about the topic of concurrent causes. Can someone give me the definition of concurrent causes?
Concurrent causes mean one or more defendants concurrently expose the claimant to the same or similar risk.
Thank you, Rafik. This can be seen in the case of Fitzgerald and Lane from 1987, where the claimant walked out onto a busy road and was later hurt by a vehicle, which pushed him into the path of another vehicle. The House of Lords held that both defendants were jointly liable, and the claimant was held contributory negligence, so they each paid 1/3 to the damage caused. Thank you.
Thank you, Miss.
Thank you, Miss.
There are in some scenarios where the defendant can be held liable even when the claimant does not prove causation on the balance of probabilities. Anyone know what is it?
Is it cases involving res ipsa loquitur?
Correct. Do you mind further explaining in detail of what that is?
So deducing from everything that has been said on causation, it is most certain the plaintiff bears the ultimate burden of proof to show that the damage was in fact caused by the defendant's negligence after showing a breach of duty of care. However, there are circumstances in which the facts of the case are such that the injury complaint could not have happened unless there had been negligence. The maxim res ipsa loquitur supports this, and translating this phrase, it merely means that the facts speak for themselves. This means that it is unquestionable that the negligence had caused the damage when the facts are sufficiently evident, and in a situation like this, the claimant's burden to prove causation won't be needed, as the elements of negligence had already been established upon the courts, and it is up to the defendant to discharge the burden of proof, showing that the negligence did not in fact cause any damage. However, do be cautious that the courts will infrequently allow this maxim to be applied, unless the facts of a case is crystal clear, showing that no damage will be caused unless there has been negligence.
Do you have any cases to illustrate as an example?
Certainly. An example of res ipsa loquitur can be seen in the case of Mahern and Osborne, 1939, where the courts held that a swab left inside the claimant after a stomach operation could not have gotten there unless someone had been negligent. The facts here are so obvious that the claimant did not have to prove factual causation. Not every day in our normal lives do we hear someone leaving a swab inside another's stomach, which is why this maxim is hardly to be used and accepted, and in normal circumstances, it is still the claimant that has to prove factual causation on the balance of probabilities.
So next week we will be touching on legal causation. Can any student give us a brief run through on what we will be studying?
So legal causation differs from factual causation, when factual raises the question of whether the damage resulted from the breach of contract or duty. Once this has been established, what is needed to ask is whether the law is prepared to attribute the damage to that breach. without the factual connection in mind. If the damage is too remote, then it won't be recoverable. And even if there is a factual link between loss and the cause. There are two tests. Does anybody know?
Is it a direct consequence test and the reasonable foreseeability test?
Correct. You must have studied very well. The traditional direct consequence test of whether the damage was too remote was laid down in re Polymis and essentially imposed liability for all direct physical consequences of a defendant's negligence. For example, in the case of re Polymis, a worker carelessly dropped the plank which caused a spark igniting the petrol vapor. The ship thus completely burnt. The court held that it was irrelevant whether the fire was reasonably foreseeable and that the defendants are liable for any damage which is a direct result of their negligence, even if more serious than they could have foreseen. Though later on, a new test was laid down in the Wagon Mound No. 1, where due to the negligence of the defendant's employees, some oil from the ship leaked to the water. This spread to the claimant's wharf and caused damage on the slipway. Additionally, that oil caught fire also and damaged the claimant's boat. The Privy Council stated that the re-Polymis principle was no longer good law. The new test established was the foresight of the reasonable person. Was the kind of damage suffered by the claimant reasonably foreseeable at the time of the breach of duty? Under this test, the defendants were only liable for the damage to the slipway and not for the fire damage. Though there's also need to analyze the type of damage, like which type of damage is reasonably foreseeable and whether the extent of the damage is reasonably foreseeable, like the eggshell skull rule and risk of damage. But do I need to talk about this?
No need. Good job, Rafik. Thank you.
Okay, thank you so much, Miss Catherine and Miss Yvonne, for joining us today and sharing your expertise on causation with the class. Do the students have any further questions? No, okay, great. So to conclude, we touch on factual causations, which include a but-for test, multiple causation, loss of chance cases, intervening acts, multiple tortfeasors, and concurrent causes, as well as a brief explanation of the legal causations and res ipsa loquitur from Rafik and Reid. And remember, although the but-for test is most frequently used when attempting to distinguish causation, there are instances and situations as to where the but-for test will not be best applied as it may not bring the results or answers that the courts need. Thus, following what was explained from our guest lecturers, as well as the understanding of the students, the main brunt of determining causation comes from the claimants having to bring forth proof, as well as the facts of the situation and what caused the injury or damage. But bear in mind, from the cases and legal principles that we've just discussed, it is not always necessary for this to happen, as there will be circumstances where the but-for test isn't always applicable. Thank you, class. See you next week. Don't forget the test, yeah?
Thank you, Miss.
Got test, Miss.